According to Section 3 of the Indian Evidence Act defines that evidence can be divided into two categories, that is oral evidence and documentary evidence. But apart from that, various terms have been used in the law of evidence which somehow differentiate among various kinds of proofs produced before the courts in India. There are pieces of evidence which hold more importance and reliability as compared to others. So, on the basis of that evidence can be categorized into 1. Primary evidence, 2. Secondary evidence, 3. Real evidence, 4. Hearsay evidence, 5. Judicial evidence, 6. Non-judicial evidence, 7. Direct evidence, and 8. Circumstantial evidence or indirect evidence. Oral evidence is dealt with under Section 60 of the Indian Evidence Act 1872. Oral evidence is defined under Section 3, which explains that all statements which the court permits or requires to be made before it by witnesses. In relation to matters of fact under inquiry, such statements are called as oral evidence. The word oral itself describes its meaning as something spoken or expressed by mouth. So, anything which is accepted in the court in relation to the inquiry and expressed by any witnesses who are called in the trial is termed as oral evidence. Oral evidence also includes the statements made by the people in signs and writing forms. Oral evidence must be direct in all cases. Indirect ways or hearsay is not considered a part of direct oral evidence. The word direct in all matters must mean that it is administered by any person on their own, that is, through their personal knowledge, and is not hearsay. For example, A tells B that he will kill C. A's statement is oral evidence. Section 3 of the Act defines the term document. Any matter which is expressed or described on any substance by means of letters, figures, or remarks, or by more than one means, and which can be used for recording the matter is considered as a document. The documents produced before the court as evidence are the documentary evidence, and there must be primary or secondary evidence to prove the contents of the documents. Documentary evidence helps determine the attitude, intention, and consciousness regarding the custom is viewed to be more important than oral evidence. For example, marriage certificate, medical records, birth certificate, written contract, affidavits, etc. Primary evidence is considered the best quality of evidence and is referred to as the documents produced before the court of law for inspection. Section 62 of the Indian Evidence Act 1872 explains primary evidence by stating that when a document is in various parts, each part of the document forms a part of the primary evidence. But if the documents are merely copies of a common original work, then they cannot be considered as a primary evidence of the original work. For example, CCTV footage, audio recordings, video recordings, etc. Secondary evidence, as the name suggests, is the evidence that is used in the absence of any primary evidence and is defined under Section 63 of the Indian Evidence Act 1872. Copies of the original must ensure the accuracy of the originals. It means that a copy which has been transcribed from the original is considered as secondary evidence and is admissible in the court of law. The copy so produced must be compared with the original and then it be called as secondary evidence. If not compared, then it fails to be secondary evidence. For example, photocopy of a document. When the evidence is brought to the knowledge of the court by inspection of a physical or material object and is not derived from witness or document, then it is called real evidence. It can also be called the most satisfactory witness. For example, murder weapon, blood samples, and fingerprints, the conduct of a witness, the party's behavior to a case, the local inspection by the court, etc. Whenever information passes through indirect channels such as rumors or gossip, it can be termed as hearsay. Hearsay evidence is the information which has not been obtained through direct means. Hearsay evidence is not as admissible in court and does not hold evidentiary value. For example, A is the eye witness to a murder case. He saw B killing C. However, later during the proceeding, A develops a mental disorder. Due to mental disability or insanity, the court will not able to admit A's testimony. However, D overhears a conversation between E and F about B planning to kill C. In such an exceptional case, the court may rather consider D's statement as hearsay evidence to structure its further proceedings. Evidence received by the court of justice in proof or disproof of facts before the court is called judicial evidence. For example, confession made by the accused in the court, statements of witness, and documentary evidence and facts for the examination by the court is judicial evidence. Non-judicial evidence mainly refers to the confession made by the accused person outside the court of law and in presence of any person. If such evidence is proved in the court of law, then it takes the form of judicial evidence. Direct evidence is evidence that establishes a particular fact without the need to make an inference in order to connect the evidence to the fact. It supports the truth of an assertion directly, that is, without the need for an intervening inference. It directly proves or disproves the fact. So, direct evidence is real, tangible, or clear evidence of a fact, happening, or thing that requires no thinking or consideration to prove its existence. The evidence of witness in court is direct evidence as opposed to a testimony to a fact suggesting guilt. Moreover, in case a statement was given before the police, it can be called circumstantial evidence of complicity and not direct evidence in the strict sense, that is indirect evidence. Circumstantial evidence is also known as indirect evidence. For instance, suppose nobody has seen who did the murder. Now the court or the judge uses reasoning and logic to come to the conclusion by cross-checking all the evidence that is available to him. For example, footprints on the crime scene floor may become a possibility for the person to be a suspect in a case. So that's all, my friends. Hope you like the video, and if you do, then please like and subscribe my channel. It will encourage me to make more videos like this. Thank you.